Hey everybody, it's Dugan Kelley with Kelley Clark. So glad you're here. We just had a recent court decision just handed down by the Eastern District of Texas, the Sherman Division. Judge Mazzant just issued a preliminary injunction on December 3rd, 2024, essentially staying the enforceability of the Corporate Transparency Act. For those of you that have an entity out there, a limited liability company, limited partnership, or other type of entity, you are probably aware of the Corporate Transparency Act, either through your certified public accountant or social media. Certainly, if you're somebody in business and you're acquiring assets through an entity like this, understood that the Corporate Transparency Act forced you to do certain things, that file and disclose through filings who actually own the entity, who is in control of the entity. And there was a lawsuit. There was a lawsuit brought by Texas Top Cop Shop Inc. et al. Against Merrick Garland, the Attorney General of the United States, challenging the constitutionality and the enforceability of the Corporate Transparency Act. Well, Judge Mazzant on December 3rd handed down an order granting a preliminary injunction, essentially staying the enforceability of the Corporate Transparency Act. And the court essentially ruled that the Corporate Transparency Act intrudes upon each state, not just Texas, but each state's rights to govern as provided for in the 9th and 10th Amendments of the U.S. Constitution, and that the Corporate Transparency Act compels speech and burdens the plaintiffs' association under the First Amendment, and that the Corporate Transparency Act violates the Fourth Amendment by compelling disclosure of private information that is otherwise currently not required to be disclosed absent the Corporate Transparency Act. So the court actually ruled, and here's the ruling. It says, having determined that the plaintiffs have carried their burden, the court grants plaintiffs' motion for a preliminary injunction. Therefore, the CTA 31 USC section 5336 is hereby enjoined. That's just fancy lawyer speak for saying that it is not going to be held enforceable. Enforcement of the reporting rule 31 CFR 1010.380 is also hereby enjoined. That was the requirement for you that own an entity to actually provide information and file that in a timely fashion. And the compliance deadline is also stayed under Section 705 of the APA. Neither may be enforced, and reporting companies need not comply with the CTA's January 1, 2025 BOI reporting deadline pending further order of the court. So what does that all mean for you? If you would own an entity that fell within the jurisdiction and you were not exempt from having to report under the Corporate Transparency Act, that obligation for you to report is now stayed, meaning you don't have to do that absent further order of the court. Now, will this be permanent? The answer is it is unknown. The Department of Justice has the ability to appeal that decision. It could go up to a higher court, as certainly the Supreme Court could comment on the constitutionality of the Corporate Transparency Act. But this is hot off the presses, December 3rd, 2024. Hope you're well. Talk to you soon.